years thereafter, January 1, 1932. Article 2 of the RPC provides for the application of the revised penal code. Article 2 of the RPC provides, except as provided in treaties and laws of preferential application, the provisions of the revised penal code shall be enforced not only within the Philippine archipelago, its atmosphere and interior waters, but also outside of its jurisdiction against the following. First, those who should commit an offense while on a Philippine ship or airship. Second, those who should forge or counterfeit any coin or currency note of the Republic of the Philippines or obligations and securities issued by the government of the Philippines. Third, those who should be liable for acts connected with the introduction into the Philippine Islands of these forged or counterfeited obligations and securities. Fourth, those who, while being public officers or employees, should commit an offense in the exercise of their functions. And lastly, those who should commit any of the crimes against national security and the law of nations as defined in Title 1, Book 2 of the RPC. This is the application of the RPC as provided for in Article 2. The first paragraph provides for the intra-territorial application of the RPC. This is the circumstance wherein the RPC shall apply for every crime committed in the Philippines, territoriality characteristic of penal laws, except as provided in treaties and laws of preferential application. So if the Philippines entered into a treaty exempting certain individuals from following the revised penal code, exempting certain individuals from criminal prosecution, the said treaty entered into by the Philippines shall prevail. That's why it is except as provided in treaties and laws of preferential application. The second part, or the second paragraph of Article 2, provides for the extraterritorial application of the RPC. These are the instances wherein the revised penal code would apply even if the crime is committed outside the Philippine territory. So these are the instances which are said to be the exceptions to the territoriality characteristic of our penal laws. The first, those who should commit an offense while on a Philippine ship or airship. The offense must be committed while on Philippine ship or airship. A vessel or an aircraft is said to be a Philippine ship or airship when it is registered and licensed under Philippine laws. Ownership of the vessel is immaterial. What is material is where is the vessel, where is the aircraft registered. If it is registered, licensed under Philippine laws, even if it is owned totally by Malaysian citizens, by US citizens, since it is licensed, registered under Philippine laws, it is considered a Philippine ship. It is considered as a Philippine vessel or a Philippine airship. The circumstance, those who should commit an offense while on a Philippine ship or airship. This refers to a situation wherein the Philippine ship or airship was no longer in the Philippine territory, but is not also in the territory of a foreign country, and a crime was committed on board. Still, Philippine laws would apply. Because if the said Philippine ship or airship is already on the territory of a foreign country, then the laws of the said foreign country would already apply because they also have the so-called territoriality principle. So the Philippine vessel, there is this vessel, let's say MV Sweet 16 is a vessel owned by Filipinos and registered also in the Philippines. So it is a Philippine vessel. It is en route to Malaysia. It has just left Manila Bay 5 minutes thereafter when suddenly one of the persons on board the said Philippine vessel, X, a Malaysian citizen, saw his longtime enemy Y sitting on a chair inside the said vessel reading the newspaper. And so, upon seeing that, he immediately pulled out the knife, rushed towards Y, grabbed the newspaper that he was reading, and stabbed Y repeatedly. X was arrested. He was brought to Philippine courts. He, however, argued he cannot be prosecuted before the Philippine courts because he is a Malaysian citizen and his victim is also a Malaysian citizen. He should be brought to his own country, Malaysia. Can he be prosecuted before the Philippine courts, or is his argument tenable? His argument has no merit. He can be prosecuted before the Philippine courts. The said crime was committed on board the Philippine vessel, while the said Philippine vessel is in Philippine territory, in Philippine waters. Therefore, under the so-called intra-territorial characteristic, territoriality principle, our penal law should apply even if he is a foreigner. But what if the said Philippine vessel is already on outside the Philippine territory, but not in the territory of any foreign country? The said Philippine vessel is on international waters, on the high seas. When the said incident happened, X, on board the said vessel, a Malaysian citizen, saw his enemy, grabbed the newspaper that the enemy was reading, and stabbed the enemy. The said enemy died. X was brought to the Philippine courts. X was prosecuted for the crime of murder. Same argument, according to him, he is not liable because he is a Malaysian citizen. And further he said, although the crime was committed on board the Philippine vessel, it is no longer within the Philippine archipelago. Therefore, according to him, he should be brought to Malaysia and be prosecuted in Malaysia and not before Philippine courts. Is his argument correct? Again, his argument has no merit. Here, what is applicable is the second paragraph of Article 2, the extraterritorial application of the RPC. Although the said Philippine vessel is no longer within the Philippine archipelago, since it was committed in a place not owned by any country, although outside the Philippine archipelago, the Philippines still has jurisdiction. Under Article 2, second paragraph, those who should commit an offense while on a Philippine ship or airship. But what if the said Philippine vessel was already on the waters of Malaysia? While the Philippine vessel was already on the waters of Malaysia, this Malaysian citizen X stabbed Y and killed Y. Can he be prosecuted before the Philippine courts? Although the said crime was committed on board a Philippine vessel, since the Philippine vessel is already in the territory of a foreign country, X can no longer be prosecuted before the Philippine courts. Here, it is the territoriality principle of penal laws that will apply. It is Malaysian laws, Malaysian courts that will have jurisdiction over X, because the crime was committed in their territory. A, B, C, D, and E went to Indonesia. They are all Filipino citizens. They check in a hotel. Thereafter, inside the said hotel, they counterfeited Philippine peso coins. They have this device used in counterfeiting Philippine peso coins issued by the Bangko Sentral ng Pilipinas. They were there doing this thing when they ordered and asked for room service. The room boy knocked, the room boy entered, the food was entered, and there the room boy was shocked. Peso coins were scattered on the floor, on the table, they were everywhere. And this room boy informed the head of the said hotel and informed the authorities. The police authorities of Indonesia arrived and they arrested A, B, C, D, and E. Can A, B, C, D, and E be prosecuted before Philippine courts? A, B, C, D, and E can be prosecuted before Philippine courts for counterfeiting Philippine peso coins under the extraterritorial application of the RPC. Even if the crime is committed outside the Philippine archipelago, Article 2, second paragraph applies. The fourth circumstance for the extraterritorial application of the RPC, those who, while being public officers or employees, should commit an offense in the exercise of their functions. This refers to public officers and employees of the Philippine government working assigned in a foreign country. If, in the course of the performance of their functions in the said foreign country, they would commit a crime, they would commit an offense in connection with the performance of their functions, they can be prosecuted before the Philippine courts. the extraterritorial application of the RPC applies. But if the crime they commit is not in any way connected with the performance of their functions, they can only be prosecuted before the courts of the said host country. Reason is, although they are public officers and employees of the Philippine government, they acted in their private capacity because the act they performed is not in connection with the performance of their official functions. What if there was this overseas Filipino worker? A Filipino worker who is working in Japan, and he was following up something, a document at the Philippine Embassy in Japan. And it was to be signed by the it was to be signed by the consul of by the Philippine consul in Japan. He was making a follow-up. And while he was making this follow-up, he discovered that the said needed document by her was not yet signed by the consul. And so she talked to the consul asking to prioritize the document. It has been on his table for more than 2 weeks. And so the consul invited the said Filipina outside. Invited to a hotel, they had drinks, and the consul told the said OFW that I could easily sign this document. That is, if you would sleep with me tonight. And so the said Filipina agreed. They checked in a hotel, and the said consul had carnal knowledge of the said woman. Because the woman agreed, because she desperately needed the signature of the consul in the said document. Indeed, the consul signed the document after their sexual congress. But when the Filipino went back to the Philippines, the said Filipino filed a case against the consul. He filed a case of abuses against chastity against the said consul. Will the case prosper? The consul countered, he cannot be held liable for abuses against chastity. According to him, the said act was committed not in the Philippines. The said act was not related to the performance of his function. Are his defenses tenable? His defenses are not tenable. His defenses have no merit. The said act is in relation to the performance of his function. It is in relation to the performance of his function because the said act was asked by him from the said Filipina as an exchange for the signature in the said document. Were it not for the said sexual congress, he would not sign the said document needed by the said overseas Filipino worker. Hence, it is connected in relation to the performance of his functions. And since it is connected in relation to the performance of his functions, therefore, he can be prosecuted before the Philippine courts. But what if this Filipino consul attended a party in Japan? In the said party, he met many overseas Filipino workers. He found one attractive. After having some drinks with this woman, they checked in a hotel and had carnal knowledge of the said woman, but the woman refused. But by means of violence, the said consul had carnal knowledge of the said woman inside the said hotel. The said woman wanted to file a case against the consul. Can he file a case before the Philippine courts, or must it be filed before the courts of Japan? The case of rape can only be filed before the courts of Japan, not before the Philippine courts. Because the said act of rape was not in connection with the performance of his function, and it was committed not in the Philippines, but in the territory of Japan. Based on the territoriality characteristic, therefore, the said consul can only be prosecuted before the courts of Japan. Then we have the last one, the last circumstance for the extraterritorial application of the RPC. Those who should commit any of the crimes against national security and the law of nations. For all crimes against national security, treason, conspiracy and proposal to commit treason, misprision of treason, espionage, inciting to war, giving motives for reprisals, violation of neutrality, correspondence to hostile country, and flee to enemy country, all of this can be prosecuted even if these acts were done outside the Philippine archipelago. Likewise, piracy, qualified piracy, mutiny, and qualified mutiny, the offenders can also be prosecuted before Philippine courts even if outside the Philippine archipelago. Extraterritorial application of the RPC. 2015 bar exam. What are felonies and how are felonies committed? 3%. Felonies are acts or omission in violations of the revised penal code. In violation of the law that refers to the revised penal code. And under Article 3, felonies may be committed not only by means of deceit or dolo, but also by means of fault or culpa. There is deceit or dolo when the act is done with deliberate intent. There is fault or culpa when the wrongful act results from imprudence, negligence, lack of foresight, and lack of skill. So we have two kinds of felonies. We have intentional felony and the other one is culpable felonies. Intentional felonies are those committed by means of deliberate intent. The elements are first, criminal intent on the part of the offender, freedom of action in doing the act on the part of the offender, and intelligence of the offender. The other one is culpable felony. There is a culpable felony when the wrongful act results from imprudence, negligence, lack of foresight, and lack of skill. The elements of a culpable felony are criminal negligence, freedom of action on the part of the offender, and also intelligence of the offender. Both intentional felonies and culpable felonies are considered as voluntary acts. An intentional felony is a voluntary act because, by its very definition, it is committed by the offender, knowingly, willfully, by means of deliberate intent. On the other hand, although a culpable felony, what is present is negligence and not deliberate intent, still, it is considered as a voluntary act. Because under Article 365 of the revised penal code, in culpable felony, the wrongful act results from the voluntary but without malice or deliberate intent doing or failing to do an act from which the injury results. Therefore, based on its definition under Article 365, it is also a voluntary act, although there is no malice or deliberate intent. Insofar as intentional and culpable felonies are concerned, a common element of these two is the so-called freedom of action. There is freedom of action when the offender performs the act on his own free will, without duress, without force on his part, without uncontrollable fear. If the accused committed the crime because he acted under the compulsion of an irresistible force, because he acted under the impulse of an uncontrollable fear, he is exempted from criminal liability. It is among the exempting circumstances under Article 12. Reason is, there is no freedom of action. Likewise, when the accused who committed the crime has no intelligence, when an imbecile, an insane, or a minor 15 years of age or under is the accused, he, according to criminal law, acted without intelligence. Therefore, he is exempted from criminal liability. It is an exempting circumstance under Article 12 of the RPC. The first element in case of an intentional felony is criminal intent. Intent is the use of a particular means to achieve the desired result. Since intent is an internal state of the mind, intent is determined, established by the overt acts performed by the offender in the commission of the crime, or the means employed by the offender to execute the crime. If the offender makes use of a lethal or bladed weapon in attacking another, that reveals intent to kill. If the offender takes the wallet of another without the consent of the owner, that shows intent to gain. So here, criminal intent is revealed, established, determined by the overt acts done by the offender in the commission of the crime, or by the means used by him in the execution of the crime. There are two kinds of criminal intent. We have the so-called general criminal intent and specific criminal intent. This is a common bar problem. Sometimes the question is, define general criminal intent and specific criminal intent, or distinguish general criminal intent and specific criminal intent and illustrate the two. General criminal intent is presumed by law from the mere doing of the act. Therefore, the prosecution need not prove general criminal intent because it is the law that presumes the presence of general criminal intent. Whereas specific criminal intent is never presumed by law. Specific criminal intent, just like any other elements or ingredient in the commission of the crime, must be proven beyond reasonable doubt. If specific criminal intent is not proven by the prosecution beyond reasonable doubt, then the accused has to be acquitted of the crime charge, or the accused may be convicted of another crime but not of the crime charge, because specific criminal intent has not been proven beyond reasonable doubt. In the course of a fight, X stabbed Y. Y died. X said he has no intention to kill Y. His intention was only to threaten Y. However, in the course of the said fight, he was able to stab Y and result in the death of Y. But really, he has no intention to kill Y. Will his defense lie in his favor? His defense would not lie in his favor. Since the victim died, intent to kill here is a general criminal intent which the law itself presumes. In fact, the prosecution, the state, need not prove criminal intent to kill. The law presumes it because the victim died, because the best evidence of intent to kill is the fact that the victim died. But what if in the course of the said fight, X stabbed Y, hitting Y near the stomach? Y was brought to the hospital. The doctor said it is a non-fatal wound. And so Y filed a case of attempted homicide against X. X, however, said he has no intention to kill Y. Is intent to, or must intent to kill be proven by the prosecution? Since the crime charge is attempted homicide, the state, the prosecution has the burden to prove intent to kill beyond reasonable doubt. If the prosecution failed to prove intent to kill on the part of X when he stabbed Y, hitting Y near the chest, inflicting a non-fatal wound, then the court can only convict Y of the crime of serious or less serious or slight physical injuries, depending on the need for medical intervention, because intent to kill wasn't proven beyond reasonable doubt. Here, what we have is a specific criminal intent. A day after their heated argument, so a day after the heated argument between X and Y, X was on his way to work. While X was on his way to work, Y and his two brothers suddenly appeared in front of X. Y and his two brothers began mauling X. Y and his two brothers boxed him, kicked him, all of them acting at the same time. And when X was already pinned down on the ground, they even used stones and hollow blocks to hit him. Y and his two brothers only stopped and hurriedly left the scene when they heard the siren of a police car coming. Y was brought to the hospital by the people nearby. And based on the medical certificate, although Y sustained wounds all over his body, these wounds were only superficial in nature. So, a case of attempted murder was filed against Y and his brother. And when this case of attempted murder was filed against Y and his brother, the contention of Y and his two brothers were that they had no intention to kill the victim. Therefore, if ever they are liable, it should only be slight physical injuries and not attempted murder. If you were a judge, would you convict the accused while his two brothers as charged attempted murder, or would you convict them only of slight physical injuries as provided for in the medical certificate? They sustained only superficial injuries. If you were the judge, you have to convict the accused of attempted murder. In the case of Rivera versus People, the Supreme Court said, the following factors will determine the presence of intent to kill. First, we have the so-called evidence of motive. Second, the nature and number of weapons used by the accused. Third, the nature, number, and locations of wounds inflicted on the victim. Fourth, manner of committing the crime. And fifth, the acts or statements made by the accused before, during, and after the commission of the crime. These factors would determine if there is, on the part of the accused, intent to kill when they mauled the said victim. So going by these requisites, these factors, according to the Supreme Court, first, was there evidence of motive? There was. X and Y had a heated argument prior to the mauling incident. Second, the nature and number of weapons used by the accused. The accused used their fist in boxing the victim, their legs in kicking the victim. They used stones and hollow blocks. Third, the nature, number, and location of wounds inflicted on the victim. The victim sustained wounds all over her, all over his body. Fourth, manner of committing the crime. The accused acted in a synchronized manner in conspiracy. They attacked the victim simultaneously at the same time. Fourth, fifth, the acts or statements made by the accused before, during, and after the commission of the crime. Before the commission of the crime, they surrounded the victim. During the commission of the crime, they acted simultaneously in conspiracy, wounding the victim. After the commission of the crime, when they heard the siren of the police, they immediately left. All factors would reveal there was, on the part of Y and his two brothers, intent to kill. Therefore, they should be convicted of attempted murder because of the presence of treachery and abuse of superior strength. But what if in the same problem, with different facts, let's say that a day after the heated argument between X and Y, X was on his way to work. Suddenly, there appeared Y and his friends, A, B, C, D, and E. And all of them, 6 of them, surrounded X. At the signal of Y, A, B, C, D, and E, all of them began mauling, boxing, and kicking the said victim X, until X was pinned down on the ground, injured. After seeing that X was already injured, Y told A, B, C, D, and E, tama na yan, sibat na tayo. Matututo na yan, hindi na yan uulit. And they left. X was brought to the hospital. X sustained injuries that would heal for 2 weeks, that is 14 days. And because of this, the accused, Y, and his cohorts, his friends, were charged as conspirators for the crime of attempted murder. If you were, based on the medical certificate, again, the wound sustained would heal within a period of 14 days. If you were the judge, would you convict the accused, Y, and his cohorts of the crime of attempted murder, or would you convict them only of less serious physical injuries? If you were the judge, you have to convict them only of less serious physical injuries. Based on the facts, obviously, there was no intent to kill. There was no intent to kill based on the acts and statements made by the accused in the commission of the crime. After they had wounded the victim, at the signal of the head of the said group, that is why, tama na yan, matututo na yan, hindi na yan uulit. It means they had no intention to kill the victim, they only intended to injure and teach the victim a lesson. Therefore, it should not be attempted murder. This time, it should be only less serious physical injuries. It is 12 o'clock. You have your lunch break. I will continue at 1 o'clock.